Good afternoon. Welcome again to edition number 6 of ChrisChat, where we do a little education on the law. Hopefully, we'll teach folks a little bit of something so that they can head out there into the world and have a better sense as to what their rights are in the community, in terms of their civil rights, their rights under the Bill of Rights. Specifically in relation to interactions with the government. As I've said many times here before and on my Facebook page, the idea here is to educate always. I get paid to advocate, but I will certainly take a position if need be. And if you have any questions along the way, by all means, please write them in, and I'll try to get them as I can. What I want to talk to you about today, and what I had scheduled to talk to you about, relates to the Miranda rights. We all know them, or at least most of us do know them. We've seen them as a trope on television for the better part of 50 years now. We just had the 50th anniversary of the Miranda decision back in 1966. So just 50, we've had 50 years of this. And what I want to talk about today is what the rights are, where they came from, what they mean specifically, as far as your interactions with the police, and also a little bit about how those rights to remain silent have been eroded over the course of the last 50 years since that Miranda decision in 1966 from the Warren Court. Let me tell you a story first. Back in 1963, there was a young girl who was kidnapped and raped, and she went to the police. Made a statement, made a description of her assailant. A few weeks down the road, a gentleman by the name of Ernesto Miranda was picked up by the police for shoplifting. He was, grabbed some things in a store, and he matched a description. Initially, the BOLO, the be on the lookout for this person who was allegedly involved in this rape. They asked Mr. Miranda to come down to the police station, and he voluntarily went to the station. He believed he was going there to discuss the shoplifting charge. He went into the police station, and some hours later, after being put in a room with the police, he signed a confession to this kidnapping and this rape. At the top of this confession, it said, "I waive my rights to remain silent," in writing out this confession. What the police did not do when they spoke to him in 1963 was let him know that he had the right to have an attorney present, and furthermore, that he had a right to remain silent. Mr. Miranda was convicted on the rape charge and the kidnapping charge in 1963. Some years later, in 1966, as I've said to you before, the case of Miranda versus Arizona made its way to the United States Supreme Court. Notice only a 3-year gap in time. There were much fewer cases that found their way onto the dockets back then. So it was a lot easier to get a case to the Supreme Court faster. Now you're looking at a much longer window of time. Anyway, in that case, in the Miranda decision, it was a 5-4 decision. And the United States Supreme Court, Justice Earl Warren, writing for the court, said that a person was entitled to have an attorney, that made a statement that if you can't do something or make a statement admissible to do a great right by doing a little wrong, that it's not sufficient to do justice by obtaining a proper result. He did the crime by irregular or improper means. And then further on into the decision, he makes the statement that you have to do the following. And this is the language from the decision. A person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have a lawyer with him during interrogation, and that if he is not able to afford a lawyer, if he's indigent, then an attorney will be provided for him at no cost or by the state. Those are the Miranda rights. There's a third one that people forget, and frankly, even the police forget this at times. When they read the rights to you, the last thing that they're supposed to say is, do you understand these rights as I have read them to you? Because a person may not be lucid, a person may not be able to understand what's happening. They may have been in a car accident. Frankly, they may have gotten their head smashed in by a police officer. But regardless, they have to have some common sense understanding of what's happening to them, especially if they, English is a second language to them. They have to be made to understand what it is that they're doing, and that's the importance of having counsel there. So what I want to discuss, those are the rights and where they came from, the Miranda versus Arizona decision in 1966. What I believe you also have to do is understand that what it means. And everybody looks at TV and they look at movies and they will tell you, well, you have to, as soon as the police arrest you, they have to read your rights. Incorrect. So I want to go over with you what the responsibility is of the police in terms of when these rights attach, when your rights attach regarding Miranda. So whenever you're dealing with a Miranda decision, some type of police interaction, your Miranda rights do not have to be read to you until two things occur. First, you have to be in custody. And secondly, there has to be an interrogation happening. Now, these words might be easily defined in a dictionary, but in terms of what their legal definition is, there's something more broad to them, certainly much more specific. So I want to go over each of those with you, what custody means and what interrogation means. First, custody. As I'll talk about in future sessions when we talk about search and seizure and things of that nature, custody has a very specific definition. Custody means that has a variety of definitions. It depends on where you are, what state you're in, but the generic idea that defines when you are in custody is the person, an objective person, in this situation, dealing with these particular police officers in these particular circumstances, answer this question: is that person free to leave the scene? That's the line. That's the gold standard when you're talking about custody. Is a person in that situation free to leave the situation, whatever the encounter is with the police? And this does not necessarily mean that a police officer has placed cuffs on you. That's not custody. Free to leave, and your custody rights can be imposed upon by a number of different factors. It's not just having cuffs placed on you. Are you free to leave has a number of different factors to it. Are there multiple police officers surrounding you? Are there more than one officer there that's in an imposing or detention fashion? Has the police officer taken their weapon out of their holster? Have they unsnapped the holster and have their hand on their weapon? A person looking at that situation would reasonably believe that if they move, that the officer is going to do something with the weapon, and therefore they are not free to leave, at least in an objective sense. Has the officer put their hands on you? Is there physical contact? Have they grabbed your arm, your hand? Have they taken property of yours to look through it? At that point, you're not just going to leave the property behind. A reasonable person would not do that. And so you are potentially could argue that you are in custody. This is another thing that you have to look at. Not just the actual physical aspect of being detained or being physically held. You also have been detained potentially based on the language that's being used. in this interaction. If you're standing face to face with one or two police officers and you're trying to move on and they're not allowing you to move on, and an officer says something to you along the lines of, don't you friggin' move, or you stay right there, or sit on that curb, or get back in your car and do it. If there's some forcible language that's being used, you then can also be considered to be detained and in custody for purposes of your rights being triggered. It depends a lot on what this interaction is, and again, it depends on each individual circumstance. There isn't a blanket to define what custody is. A judge looks at the circumstances and says, and answers for themselves. Would a reasonable person placed in this situation believe that they are in fact in custody, that they cannot leave the scene? That's one way to look at it. Is a person free to terminate this encounter if they are free to leave and move on? That's another indicator of whether a person's in custody or not. Is there some sort of a halt requirement or submission requirement? Again, has the officer, removed a weapon or in some way detained you? Have they pulled their car in front of yours to stop you from driving away in a roadside encounter? Has the officer not touched you but stood in your way while you were intending to walk away from an encounter? At that point, it could be argued that a reasonable person in this circumstance would say to themselves, I'm not free to leave. So that's the first requirement. Custody. Is a person in custody? But the second requirement also has to kick in, and that's whether someone has been or is being interrogated. And again, you might find the definition of interrogation or interrogative questions in a dictionary somewhere, but in terms of the legal definition of interrogation, there are specific things that have to happen. Interrogation for these purposes means, are the police officers or is law enforcement asking questions of you that if you make statements or answer these questions, the answers to those questions might have a tendency to incriminate you? Would these answers get you in trouble? Is it something that they could use against you in a court of law? That's the standard. Is it something that they can use against you at trial? And again, it's an objective standard. Would a reasonable person in this circumstance answering these questions, would these answers tend to incriminate someone? You have to look at those circumstances. And it's not just, the police are allowed in street encounters to ask what are called identification questions. They can ask you questions about what your name is, and specifically in Massachusetts, these things apply as well. But in general, as far as what your rights are under a Miranda stop or a Miranda situation, but specifically in Massachusetts for these cases, a police officer is allowed to ask you your name. They're allowed to get information regarding your address, where you live. And in Massachusetts, if an officer asks you to produce a driver's license or other form of photo identification, you have to not just show it to them, like hold it up in your wallet and show it to them. You have to remove the ID from the wallet or from whatever holder you have and then pass it along to the officer. The officer is allowed to manipulate that ID. Take it back. If you've been in a roadside stop, the officer takes the ID and takes it back to their vehicle and then checks up on you, and they determine whether you have any outstanding warrants or what your record is in terms of driving history. But on the street, they are allowed in the same situations to get your ID, to find out what your name is and what your address is. And that's it. That's it. Anything else beyond that treads on the ground of potentially being interrogative questions that are dangerous, questions that might serve to incriminate you. All of these types of things could be considered interrogation. Where people stumble, where people have problems is in the area of things that might be statements that you might think would incriminate you, but they are not protected by Miranda. So we call these specific statements non-Miranda statements. Again, the first non-Miranda statement would be what the police would refer to as pedigree information. They're allowed to ask where you live, who you are, and get your driver's license information, or if you're not a driver, your Massachusetts ID if you're in Massachusetts, or any other place that has a photo ID that can sit in place of a driver's license. They're allowed to ask those questions. They're allowed to ask, and what is not protected by Miranda are voluntary statements. If you, in the course of a police interaction, simply blurt something out, and it's not been prompted or forced out of you or in some way an answer to a question, if you simply blurt something out voluntarily, they can use that against you. That's a voluntary statement. It's not something that is deemed to be coerced from you as a result of an interrogation. So they can use voluntary statements. Furthermore, if you make this voluntary statement, you have in essence opened the door for the police to continue to ask you other questions. They can, if they ask you clarifying questions about what you said and you answer them regarding those things, then again, you are also potentially liable to not be protected by Miranda in terms of what those statements are and how they can be used against you. So pedigree statements, routine, arrest type things, routine contact in Massachusetts, your name, your address, and your ID. Volunteered statements that you just blurt out. And third, clarifying questions related to statements that you've already made. There is a fourth type of statement that is not Miranda protected, and this is one that frankly has been used much more so over the past 15 or so years, given the 9/11, given Patriot Act, and given the terrorism hype regarding statements. But the actual impetus for this type of exception to Miranda comes from 1984 in the case of New York versus Quarles. Person was charged with rape in that case, and apparently the victim said that he had a gun. When they grabbed Quarles, who ran from the scene when the police came, they noticed that he had an empty holster, and they asked him, "Where's the gun? Where's the gun?" They had him on the ground, and they're asking him, "Where's the gun? Where's the gun?" And he then told them. They didn't give him his Miranda rights during that interaction. He tried to have that statement excluded when he told them where the gun was. And the United States Supreme Court created what they call a public safety exception. That if the police are asking a question to get information that would solve a problem related to public safety, in the Quarles case, a missing gun somewhere on the streets of New York, that was allowed as an exception to Miranda. This public safety exception has been used many, many times in interrogating terrorism suspects, especially after 9/11, when they talked to Moussaoui, the 20th hijacker who didn't make it onto one of the planes. They interrogated him without giving him his Miranda rights. And the interrogation was permitted because the feds argued in that case, that he had potentially information that would be related to public safety. Are there other bombings planned? Is there another plane in the sky? When they interrogated him, they used that public safety exception. But they've also used it in a number of other terrorism situations, including, and again, this cuts close to home, the interrogation of Dzhokhar Tsarnaev after the marathon bombing 3-some years ago. When Tsarnaev was arrested and detained, he was not read his Miranda rights because they believed at the time that he had information related to other possible bombs that might be out there, or other bombs that were being created that might be out there. And so his rights under Miranda, he did not have them read to him. So there are certain non-Miranda statements that you have to be aware of. Another one that people get tripped up on, I've seen it happen more recently now, are statements made to private citizens. Your Miranda rights and all of your rights as discussed in the Bill of Rights and the 14th Amendment as they're applied to the states, all of your rights protect you from law enforcement interaction, from government interaction. The government is not permitted to do certain things. The state, the police, they're not allowed to ask these questions. But private citizens are. They're not protected. They're not covered by that. And so if you are in a job situation or somewhere at work and one of the security guards in your building starts asking you questions and you answer them, they are a private citizen. They are not law enforcement. They're enforcing the law in the building, but they are not law enforcement. So if you make statements and then those statements get to the police, they're allowed, because they don't have to read you Miranda before they give you the statements. If somebody makes a citizen's arrest, and some John Q. Law wants to pull you down on the street, and they grab you and start asking you questions, they don't have to read you your Miranda rights. Miranda only covers you in terms of police or law enforcement interaction, and that's any law enforcement. It's not just police. It could be, the T police. It could be anybody who has the power to arrest you. So those are what you're looking at. But here's something else that people also don't understand, and this is when I talk about the erosion of your Miranda rights. This is something that people don't understand. They don't automatically attach. You have to assert your right to remain silent. You have to actually say that you're asserting your rights, both to remain silent and to an attorney. It's not automatic. And the case where I'm talking about most recently is the case of Salinas versus Texas, where the United States Supreme Court created a new standard when you're looking at statements that can or can't be used. And what you think is, I have the right to remain silent, and as such, anything that I say, I can't be made to talk. That's the whole idea. If you look at the Fifth Amendment, it says I can't be made to speak. And my silence cannot be held against me. But in the case of Salinas versus Texas, there was a shooting done by a shotgun. And they arrested the gentleman by the name of Salinas, and they asked him to bring in his shotgun, for analysis. Months went by, and finally they got ballistics back on the gun, and they brought Salinas back in again. They read him his rights, and he was answering questions, and then they brought the gun back in, his gun, and they placed it on the table in front of him. And they said, now, tell me, is this gun going to match the ballistics that we know we already have related to the shots that were fired at this particular individual that ultimately killed him? Is this the gun that's going to come back as being the one that killed him? Salinas ducked his head, looked down at the floor, and didn't answer questions. He didn't say anything when the police asked him specifically about this weapon. The police then went on into a further interrogation of him, and he went back to answering questions. But he did not answer that particular question. Is this the gun that killed the victim in question? At trial, the prosecution in that case, when they got to their closing argument, argued to the jury that when he was asked this question, he didn't answer. He remained silent. And they then went further and said, don't you think that a person in that situation, when asked that question, would have said no, or they would have made a response to that question? Instead, he stayed silent. And then they moved on. And that, in essence, what they did was they used his silence as evidence of his guilt. The fact that he didn't answer the question, hung his head, and didn't say anything. He was convicted. He appealed his conviction to the United States Supreme Court, specifically as related to the closing arguments of the prosecutor, in saying that the prosecution used his silence against him, which is specifically prohibited by the 5th and 14th Amendment. And yet, the United States Supreme Court in Salinas said that he had to affirmatively state at that point, because he was already answering questions, he had to affirmatively state his right to remain silent at that point. He didn't. And the Supreme Court created what we now know in Salinas as the use it or lose it exception to the United States understanding of what Miranda means. That if you don't assert your right to remain silent, then your silence, at least in terms of Salinas, can be used against you. A number of states will now go down that road of amending their courts, their case law to address this particular circumstance. And this is a dangerous road down which we are going. That if you are going to allow silence to be used against people in a court of law, you've in essence taken the entire guts out of half of the Miranda rights. Because Miranda addresses two parts. They address both the Fifth Amendment right to remain silent, and they address the Sixth Amendment, your right to counsel during questioning. You can waive your Miranda rights. You can. But you have to do it in a certain fashion. There's a rule. It's called the Burbine Rule. And you have to prove, or the prosecution has the obligation to prove, if you contest it, that either you've A, expressly waived your rights after being told what they mean. Remember, your right to remain silent, your right to counsel, and that you understand these rights as they have been read to you. You have expressly waived them on paper. But you can also be deemed to have waived your rights in an implied fashion. And the police can argue this, prosecution can argue this as well, by saying that if you understand your rights and they prove that you understood them, and that you volunteered to answer questions, at that point you are considered to have waived your rights. But it requires two things. First, that you did it voluntarily. They can't beat your waiver out of you. They can't threaten your waiver out of you. They have to determine whether these statements that you made were not done so in a fashion that was manipulated or coerced or another way extracted from you that would somehow deprive you of your ability to confess or make your statements autonomously, freely. Second part of Burbine, when you're looking at this, is to make sure that the person understands what they're doing. A clear and careful administration of Miranda is key in that situation. You have to look for a number of different factors when you're looking at whether somebody has waived their rights or whether they understand. And this goes all the way back to the beginning. Do you understand these rights that I've read them to you? You have to observe the competency of the person you're talking to. If they're a person who is just generally incompetent, if you're looking at somebody who's mentally or physically challenged, who may not be able to understand what their rights are, you have to step back and look at that in terms of voluntariness, in terms of understanding. The basic intelligence of the person can be brought into question. Their education, their age. Miranda is required for kids. Juveniles have Miranda rights. If you are arrested as a juvenile, you have the right to remain silent and you have the right to counsel. They can also look at your familiarity with the system. If this is your first time through and you're a new English speaker or something of that nature, that comes in. But if you are what we would call a frequent flyer or a veteran of the system, it's presumed in a sense that you understand what your rights are and that you understand them as they've been read to you. They have to look at whether you are under the influence of drugs, whether you are under the influence of alcohol or something of that. All of that comes in terms of not just your understanding of what's happening to you, but also the voluntariness aspect. If you are not in a state where you can knowingly, competently make a waiver of your rights, then it's not allowed. You cannot do it. So those are your Miranda rights in terms of your right to remain silent. But you have two halves of this. You have the first half, which deals with your right to remain silent. But then you also have your right to counsel. Whereas you have to assert your right to remain silent at that beginning. Now, we talked about Salinas and how you have to use it or lose it. With the Sixth Amendment, you have to assert affirmatively your right to counsel. It is triggered in terms of your right to counsel at the time that they're beginning to interrogate you. But you also have the Sixth Amendment right to counsel in terms of protecting you in court. So there are two different parts of the Sixth Amendment there. What I'm talking about today is your right to counsel in terms of interrogation. And that is triggered when you are given these rights and then you assert them. And again, you have to actually state, I want my attorney. You can't say, if it's something along the lines of, do you think I might need an attorney? Or I guess I should probably call an attorney. Or, wow, a lawyer would really help right now. Those aren't enough. You have to actually state, I want counsel present. And once you do that, they have to stop questioning you, period. They cannot continue to question you. They can come back and ask you again after a period of time has lapsed. If they continue to detain you, they can come back again and ask, are you still looking to, maintain your silence? And, if you say yes, and you have to continue to once again assert your right to counsel. You can, down the road, you can waive your rights to counsel, but they have to provide counsel to you. And if you have an attorney already on the books, maybe it's me, or maybe it's somebody else, or if you have somebody out there, you're making a phone call, they have to get allow that attorney access to you. If you tell them I'm indigent and I cannot afford an attorney, then they cannot talk to you until an attorney has been provided to you by the government. And these are not, I've heard this before. I started my practice in the public defender's office, and I would get this all the time. Well, you work for the government. They get paid by the government. Public defenders in many states are paid by the government. Some are paid by private entities who are contracted with the government. But public defenders are not tools of the government. They are your attorneys. They have to maintain your silence. They have to maintain your confidence. They have to maintain your attorney-client privilege. They are not there simply to get information from you and then turn it over to the state. So when you ask for an attorney, they have to provide it to you. They can come back at some point down the road, as I said, and ask if you want to continue remaining silent. And you can, down the road, waive your right to an attorney and talk. No differently than if you waive your right to silence, and you can go ahead and make statements. You can write a statement out or answer questions. You have that right. But again, that waiver has to be undertaken voluntarily and with understanding of what it is that you're waiving. So those are the basics in terms of Miranda. But what people fail to understand many, many times is that they find themselves in a police encounter and they don't know what it is that they can do. And what I want you to understand is that there are two different types of basic encounters that you're dealing with in terms of police interaction. First, I want to talk about A, pedestrian encounters, and B, motor vehicle encounters. What your rights are in terms of the police stopping you in those situations, because there are moments in that interaction where you may be, like we talked about, in custody, and in custody does not mean in cuffs. In custody means I'm not free to leave. An objective person in this situation would believe that they're not free to leave, A, and B, that the police are asking questions, the answers to which might serve to incriminate you. Those are the two main parts of Miranda. If you are stopped, so what I want to do is talk first about what your rights are in pedestrian encounters, and then secondly, I want to talk about what your rights are in motor vehicle encounters. First, if you are stopped by the police, you are not required to answer questions from the police. You have the right to speak to an attorney. You are not required to, you have the right to record them. You have the right to record the actions of the police. You have a First Amendment right to do so. And if they take your phone away from you, then that's a problem. That's actionable. They do not have the right to put their hands on you, to frisk you or search you or anything. We're going to talk about this down the road as well. But I want to get into, they don't have the right to put hands on you, to frisk you or search you until they have reasonable suspicion. So we'll get into that when we talk about the Fourth Amendment down the road. First, in a pedestrian encounter, if you are detained by the police, remain calm, all right? And let them know that you're exercising your rights under the Constitution to remain silent. You let them know that you're not answering questions other than telling them your name and address, that you are confirming that you are remaining silent. You're invoking your right to an attorney immediately. Don't wait until you get back to the police station. Don't. Assert it on the scene. Immediately state, I'm asserting my right to an attorney. And at that point, they have to stop. You are asserting your rights at that point against unreasonable search and seizure, and you don't consent to any search of your person. And that you're refusing to answer any questions about property ownership. If they're asking you, is this your bag? Is this your car? Is this your whatever? You are refusing to answer questions, and you continue to say, I am invoking my right to remain silent. You're continuing to do that. And then stating to them, and I know this is tough. I know it's tough. I get it. I hear this all the time when I talk to people about don't get out of the car when you've been detained by the police and don't say anything. Hand them your license and shut your mouth. And I hear, oh, if I didn't do anything, what's the problem? Here's the problem. If you're not under arrest, you let them know. If I'm not under arrest, officer, and you have no further suspicion to detain me, I'm leaving. And see what happens. Because at that point, if they put hands on you, you're in custody and everything kicks in. So in a pedestrian encounter, 1, invoke your rights immediately. Tell them you're invoking your right to remain silent. Do not answer any questions beyond basic pedigree information, name, address. You're asserting your rights against having them put their hands on you, and you are saying, if I'm not under arrest, I wish to be free to leave. I'm going. And then put it back on them to put you in a custodial situation, to actually take custody of you. I know it's scary. I get it. But if you don't want things to be used against you, this is how you protect yourself. The government, the police, want compliant sheep. They would love to intimidate you into being quiet and being good little doobies. This is what they want. This is not what you should give them. If you voluntarily give over your rights, it's a continuing spiral downward. So that's a pedestrian encounter. In a driving encounter, when you are stopped by the police, again, and I urge this, remain calm. If you begin to act agitated, or what the police would refer to as acting in a furtive fashion, or an agitated fashion, this allows them to escalate. It builds a case towards what's referred to as reasonable suspicion. You need to remain calm. Turn off your vehicle. Turn on your interior lights. So that they can see that there's nothing wrong inside the car. Put your window down, not all the way, but just enough so that you can get your hand out the window to hand over your license and to hear the officer. You do not have to put it down all the way. And if the officer tells you you have to put it down all the way, you do not have to put it down all the way. You turn your car off, you turn the lights on inside the car, put the window down part way, put your hands on the wheel until you are asked to do otherwise. You are only in a motor vehicle stop obligated to provide the officer with your license and your registration. That's it. Nothing more. Provide your ID, do that, and then let them know, just as you would in a street encounter, I am asserting my rights to remain silent. I am not answering any further questions. I do not give you consent to search my person or my vehicle. And in fact, in a motor vehicle stop, I'm not getting out of the car. I am asserting my right to an attorney. Let them know I want my lawyer. And you have to request the chance to contact one, even at the side of the road. And if they have appointed counsel, get them out there. Because I'll tell you right now, there are a few folks out there, and you know who you are, who have called me from the side of the road after an incident has occurred, and you did the right thing. You called me when there was a problem immediately, not after the fact. Getting a call at 3 o'clock in the morning on the Wednesday before Thanksgiving, and I answer the call when you've been detained by the police for suspicion of operating under the influence. That happens. But you do the right thing. You call your attorney, and your attorney talks to law enforcement and says, she's not answering questions, or he's not answering questions, or they're not answering questions. That's it. Get attorney contact involved immediately. In a roadside situation, there's a bump as well. You also have to let them know that you are not consenting to any field sobriety tests, that you're not consenting to breathalyzers, and you're not consenting to blood tests. That's your basic interaction, or what your rights are in terms of what you can and cannot do, and what your rights are in police interactions as relates to Miranda and your right to remain silent. Now, a pitch, if I may. If you have any questions, by all means, that's what I wanted to get into today. If you have any questions, please, send them along or make a comment to this video after it's posted publicly. It's already public right now, I believe, for sharing if you wish to share. But I have an organization. You can find us on Facebook. It's Street Law Saves. And what I discussed with you today here relating to your Miranda rights and your right to remain silent in police encounters, you can get one of these from me. It's backward right now, but these are little cards that you can keep in your car or on your person, and just as a reminder when you are stopped by the police or stopped in person, to have these rights handy, because you may not forget or you may panic, but you should have these rights handy. I will post my address for this, and if you want me to send one of these to you or more than one of these to you, if you want me to send 10, if you want me to send 50, if you have an organization, you want to pass these out to students or friends or whatever, and you want these cards, simply send me a notification, a message here on Facebook. You can message me with an address and I will send these out to you. My office address is 21 McGrath Highway, Suite 306 in Quincy, Massachusetts. The office is Maniscalco and Diorio. Nice Irish law firm, I know. But if you have questions or if you want these cards, that's the address for Street Law Saves as well. Knowledge is power. It always is and always will be. Understanding what your rights are in terms of police interactions, in terms of what your rights are in terms of remaining silent, and how you have to continue to vigorously assert those rights, because they are not guaranteed to you anymore. As we've seen in Salinas, they are continuing to rip away at the threads of the Fifth Amendment, the Sixth Amendment, and Miranda. Interestingly, going back to what I talked about with Ernesto Miranda, Ernesto Miranda had his conviction overturned in 1996 based on the police and their failure to read him his Miranda rights. He was released, but then he was retried on the rape and kidnapping charge. They did not use his confession against him. He did, however, make a statement to his wife at the time, talking about the kidnapping and the rape. His wife, while he was incarcerated pre-trial on the first trial, filed for a divorce and tried to restrain him from getting to his children. Miranda fought for his rights to his children, and his wife then went to the police and told them that he had confessed to her that he had committed these crimes. They used his statements to his wife, who, because they were divorced, the privilege had expired. And he was convicted again, the second time, without his Miranda rights being imposed upon. And he did 10 years in jail as a result, or he got out in 1973, parole for good behavior, etc. In 1976, 10 years after the Miranda decision had come down, Ernesto Miranda had not changed his ways and found himself in a poker game in a bar. He apparently raised the ire of a couple of the players in the game. They accused him of cheating, apparently. He went outside after the game was over, left, and he was encountered by two of the men from inside. And one of these men stabbed him. And the other disposed, allegedly, of the murder weapon. The second man, the person who apparently knew where the weapon was, but didn't say anything, because he asserted his Miranda rights in 1976 to remain silent in the face of police questioning regarding the death of Ernesto Miranda. He asserted his Miranda rights and remained quiet long enough for the person who actually did the stabbing to escape to Mexico, never to be found again. And as such, he couldn't be charged with being an accessory to a crime for which there was nobody else to convict. And so the second man was released from prison, or released from detention, and was never prosecuted as a result. An odd irony that Ernesto Miranda was murdered and that the people who killed him used their Miranda rights to avoid prosecution. Again, thank you very much for stopping in. I'm glad that you stopped in for a little bit of a ChrisChat. The video will be posted and made public if you wish to watch it again, to pick anything up along the way. If you have questions after watching the video or questions come up, by all means, comment on the video. I'm going to continue to make these public so that people can pass these along. And again, if you have a need for one of these cards, know your rights. Send me a message via Facebook, and I'll send out as many as you want or need to you individually to keep in your car, on your person, etc., so that you know what your rights are in a police encounter as far as your right to remain silent. Thank you again, and have a good weekend.